Okay, on to 8.1, which is review of open meeting and transparency laws and ordinances, and this is a presentation, an annual presentation basically, by our city attorney on the Brown Act, Open Government Ordinance, and Public Records Act.
I've been asked to provide 3 training sessions, and this is the first one. They're each one. The concept is each one will be an hour or less. I welcome questions as we go along and be happy to respond if you have something that piques your interest. As I said, this is the first training session. It'll cover some topics under the Brown Act, less so under the Open Government Ordinance and the Public Records Act, but those are the 3 topics. Mostly we'll be talking about Brown Act and about about meetings under the Brown Act and about use of social media. We've talked about many of these things before, but refresher training is, I think, very helpful because these issues constantly come up in city business. The plan is to have another training session in August to cover FPPC, conflicts, and council norms. And then in September, a more subject-focused session, which would cover certain housing laws, public contracting, design, build, and then I believe Jimmy will also give training on emergency operations. So let's talk about some of the Brown Act issues that do with meetings. As you all know on the council, and hopefully members of the public realize as well, the Brown Act is the fundamental law under which city councils in the state of California operate. It requires that local agency business be conducted in public. It protects the public's right to access legislative bodies. It requires that we have agendas that are posted and prepared in advance. And it requires that we can't discuss and take action on items that are not on the agenda. And it also allows the public to comment on all agenda items. This isn't not discussing items on an agenda comes up all the time because, for example, in our current way we do agendas, the issue of future council agenda items that we have at every meeting, we had one today, nobody said anything, but when people do have an item, we have to talk about it enough to know whether the council wants to put it on the agenda for the future, but not enough to actually discuss it, and of course we can't take action on it. The council also can, if, for example, if a member of the public raises an issue, direct staff to look into it and come back with a report. That sort of minimal kind of non-discussion is allowable. But we can't have extended discussions about the merits of a future council item. And several times that's happened, and I've appreciated it when council members have said, wait a minute, we're getting too far afield here. We have to back off a bit. The Brown Act applies to the city council. It also applies to other policy bodies like the Planning Commission, for example, or all the city commissions. And there's always an issue about what about temporary committees, what about subcommittees, does it apply to them? Generally speaking, it does not apply to a subcommittee of less than a quorum if it's an ad hoc subcommittee. In other words, if the council appoints a committee with 2 or 3 council members on it to meet for a year on one particular issue, that is not necessarily a Brown Act committee. However, if there is a quorum on the committee, in other words, 4 council members or more, or if the committee lurches into a situation where it becomes a standing committee, in other words, it kind of keeps going and the council decides to extend it, then that committee most likely becomes a Brown Act committee and has to follow the same procedures that the council itself has to follow. And we had that actually with the downtown committee, which initially formed was a non-Brown Act committee meeting for a year. The decision was made to extend it. We said that will be a Brown Act committee. And of course, when 5 council members got on it, then it definitely became a Brown Act committee. There wasn't any question about that.
Would you like questions as we go or at a certain point?
I would say as we go, it's fine.
Councilmember Armendariz, did you have a question?
I do, thank you. On the previous slide, Andy, you talk about the public can comment on all agenda items. That includes your report and the city manager's report, is that correct?
No, actually it doesn't. It shouldn't say all items. It should say almost all items. It doesn't include ceremonial items either, or proclamations and things like that. It doesn't include purely information items presented by staff, like in the city attorney's report or this presentation.
So
But there's a
not,
fine line, and it's not exactly clear always where that is.
okay, so not ceremonial items, not the city manager's report.
Right, and not the city attorney's report.
Nothing that is strictly informational.
That's correct. And there may be some other things too, but most of all of the action items on the agenda certainly are subject to public comment.
Okay,
Okay?
thank you.
Sure. So what are meetings? Under the Brown Act, meetings are defined very loosely. It says any congregation of a majority of the members of a legislative body at the same time and location, including teleconference locations, to hear, discuss, deliberate, or take any action within an item that is a subject matter jurisdiction of the legislative body. This is a very broad definition, and actually it's even broader than this, because meetings can occur on Facebook, meetings can occur on social media, meetings can occur on emails if somebody replies all. We'll talk more about that. We've certainly warned you about that in the past. It includes things called serial meetings, which are meetings that are not intended to be meetings. But if one council member talks to another one, and then another, and another, and another, one at a time, if they're talking about matters of city business, and if they're discussing these city matters, that can be a serial meeting. And it doesn't mean that a council member can't talk to another council member, but you have to be very careful when you do it, not to say, by the way, I talked to another member, and here's how they see the issue. Because as soon as you get 4 people doing that, you've got a meeting. And so there are cities that got in trouble. I think I mentioned to you perhaps before a Fremont case where the city manager had a process where once a week he would meet for breakfast with the council. And there were 5 members on the council, so he would meet at a table in a coffee shop with 2 of them. Then he'd move to another table with another 2, and then he went to the 3rd table where the last council member was. And that was held to be a meeting of all 5 of them. There was an obvious kind of subterfuge as a way of getting around having them meet together, but it doesn't work, as you can imagine. On the other hand, for example, the city administrator could talk to each of you and give you information. He can't ask you, are you okay with this? Do you approve of this project, for example, in the oldest form? But he can provide information, or a council member can provide information. So it's a little iffy about what is a meeting and what isn't, but that's a big issue on social media. And it can include, of course, phone calls, as I say, their emails, social media, text messaging, and so forth. There are exceptions, obvious exceptions. Council members are allowed to talk to the public, they're allowed to talk to their staff. They're allowed to talk to each other, actually, too. I don't mean to imply that you can never talk to each other, but you can't do it in a way that constitutes a meeting of the quorum. Council members can go to conferences. Hypothetically, if 4 council members went to a League of California Cities meeting, 3 of them could talk about city business, but if the 4th person sits down at the dinner table, that would be an illegal meeting if it continues to talk about city business. So you have to be very careful about that. There are meetings of other legislative bodies you can attend, or social events and things of that nature as well. And the last item here talks about standing or temporary committees. That's the item we talked about before. And to determine whether a temporary committee is a Brown Act committee, we look at, does it meet on a fixed schedule? Of course, if it has a quorum, it's clearly a Brown Act committee. Does it have continuing jurisdiction, or is it simply ad hoc over one minor issue, or one issue, I shouldn't say minor issue. And then, by the way, there's a interesting decision for the Attorney General about attendance by others. It basically says, if you were to appoint a standing committee that had, say, 2 council members on it, and others want to attend, they would have to attend only as observers. They can't speak. They can't take part in any way. Presumably that means they can't raise their hand, smile, do anything that indicates assent to discussions of city business. So it's something to be careful about. There's an interesting San Jose case that came out some time ago where San Jose has had a policy in certain administrations where council members will issue memoranda on projects. So, for example, a project is coming through the council, and there are 10 council members and mayor, so there are 11 votes in San Jose. Sometimes as many as 5 council members will sign off on a memo. that says, we all think this is a good project. They don't get 6 because that would be illegal to have 6. However, there was a case where there was a memo with essentially the 5, I'm changing the facts a little bit, and in an elevator, one of the 5 talked to the 6th and said, what do you think about the memo? And the 6th said something like, well, it's okay with me, or sort of, I agree, without exactly saying it. And that was held to be an illegal meeting because the 6th council member, in effect, signed on to the memo. So it's something that, again, we don't do that here in Gilroy, but it's something that one has to be careful about. There's also, for example, suppose you were contacted by an applicant for a project, and the applicant went to each one of you. In Gilroy, we allow that. Applicants can do that. They're allowed to do it. However, if they start to say, well, I talked to Council Member Tovar, and he told me he supports the project, please shut them up. That could be an illegal meeting, because you are learning how other council members feel about a given project. So it's odd because we don't normally control the conduct of non-city people, but nonetheless, we could, in theory, get in trouble because of that.
And
Yes?
if somebody says, I have support from other members, but doesn't specify whom, does that count?
Who knows? I would say it's best to say, look, I can't talk about that. All I can do is talk about your project. I can't even tell you whether I'm going to vote for it. Now, that's the safest thing to say. Because if you try to parse it too fine and say, well, I'm saying something, but it's not really in prohibited territory, who knows how that will get heard, or what that person you talk to will say you said, which might be a little different than you think you said. So it's something that we just have to be careful about. Okay, what I want to talk about now is virtual meetings. And this is, the reason I'm talking about this is something that has changed in the last couple of years. It's very confusing. We keep hearing about other cities doing things differently, and people are asking, why can't we do this? Why don't we set up our meetings in a certain way? So I'm going to try to explain the current status of virtual meetings, which is really a mess. Okay, so but nonetheless, I'll try to make it understandable. Under the Brown Act, before COVID, before we had all this technology, there was always the allowance for a certain kind of teleconference. They didn't call it teleconference, it just called it a council member being away at a remote site. This typically would happen, and we did this in Gilroy from time to time when a councilman was on vacation, for example, but wanted to attend a meeting remotely. We've had a number of council members do that. And that ability to do that, what I call traditional Brown Act teleconferencing provision, this provision is still in the Brown Act. It doesn't get the press that it used to because there are other methods, but this is still there. And what it requires is that it all be set up in advance, so that the agenda and the notice of the meeting have to specify that council member X will be attending remotely, and here's where. It might be in a hotel, or their house, or their vacation home, or even in another country. And of course, the kicker is that the remote location must be publicly accessible. So the council member who's, let's say, in a hotel has to arrange so somehow his door or her door is open or available to be open. They have to post a copy of the agenda, and in theory at least, they have to welcome a member of the public to go in to the event. Now, in terms of these kind of travel things, I've never heard of that actually happening, but that's the Brown Act requirement. And when the council member calls in, they confirm that that's what they have done. And that's all okay, and that's, as I say, been in the Brown Act for years. There are certain requirements, including that a quorum of council members must still be in the city. And you can do audio or visual. And the council member doesn't have to have, under this approach, an actual excuse. And I mention that because the next thing we'll get to does involve excuses. But so a council member can simply be traveling on vacation and want to sign in remotely, and if the city agrees and cooperates with the agenda, that can be done. Now, the next thing that came along was AB 361 due to COVID. You remember, for starting in March of 2020 and going on for a year, or a little over a year, this council virtually. And it was completely virtual, just all met on Zoom. That was a special law that's not in effect anymore, so we have to kind of forget all that. I think a lot of people thought that there were positive elements to those meetings. Many members of the public certainly reported that they enjoyed them. They liked the idea that instead of having to come here and wait while somebody drones on about something you're not interested in, you could come, you could just watch it in the background and be multitasking at home. So there was widespread assumption, certainly on the attorney's parts, that the legislature would think of some way of making that permanent. And they came up with this monstrosity called AB 2449 instead. The AB 361, the one that allowed the complete virtual meetings, has gone away because it only applied while there was a state of emergency, and that's been cleared as of February of this year. So AB 2449 is the legislature's attempt to allow a different kind of teleconferencing slightly. And it puts requirements on the city and it puts requirements on the council member who's absent. So let me explain some of these, and I think you'll see as I go through it why I called it monstrosity. So it allows teleconferencing, but there still must be a quorum of the council in a physical location. So for us, that would mean there still has to be at least 4 of you here. The person who is appearing remotely, the council member, must have two-way audio-visual participation. So in effect, that means internet, Zoom, or Microsoft Teams or something. The public can participate remotely, but not at that person's location. Or at least, let me put it that way, the person does not have to reveal the location. That part of the Brown Act is not required under this law. So that's the one advantage it has. If someone's traveling, for example, they don't have to worry about listing on the agenda where they're going to be, and they don't have to allow the public to come in. That's the last bullet point here. The remote location need not be disclosed or made available. Now, for the member, though, what do you have to do if you want to take advantage of this? And these are truly strange laws. A council member has to have either just cause or an emergency circumstance. Okay, and these are two separate clauses in the law. An emergency circumstance means a physical or family medical emergency that prevents a member from attending in person. So that's relatively straightforward. There must be a brief statement about what it is without disclosing any medical privacy information. So some kind of medical emergency. But it has to be physical or family medical emergency. Just cause is different. Just cause includes child care and care of family members. And there's a whole list of them. A contagious illness. And then another one is a need related to a physical or mental disability as defined in the government code, or travel on official business. And I actually looked up the need related to physical or mental disability. It goes on for pages. It's very wide-ranging in terms of those kind of disabilities. It's a much larger definition. Leanne probably knows this as from her job than the federal law. The state law of disability is very broad. But anyway, but there are restrictions. And this participation must be authorized by the council. And just cause, the word just implies there's something right about the cause. It's okay. But it can only be used twice per year by a council member. So there's a limit. There's no reason given why that's a limit. And either just cause or emergency circumstance cannot participate remotely for more than 3 months or 20% of the meetings. And you try to figure out what that really means. I mean, Gilroy meets roughly 24 times a year. 20% is less than 5 meetings. 3 months, we have 6 meetings. Does that mean you can have 1 meeting 1 month and one another? I really don't know. And we have never taken this into account. We've never been requested to do this. And I know Ty has told me, the city clerk, that in fact in the city clerk world, there's a widespread belief that this is not a very useful thing because it's so complicated. In addition, by the way, if we set up such a meeting and the public then can participate remotely, there must be a two-way audio-visual link with the public, or a two-way audio link and a webcast. A webcast is a one-way video link. And if it goes down, you have to stop. You literally have to stop the meeting until it gets fixed. So it's one of these things that, in theory, I think the state legislature wanted to say that we are relaxing the old rule of the Brown Act about having to make your site available to the public. But in return, they put in so many issues here and so many procedural hurdles that I think this would be a very difficult thing actually to do. And it's a big disappointment because everybody thought that there would be some sensible remote thing that came out of the legislature. It hasn't happened. And I think when it starts to happen, then there are various media and transparency interests that jump into gear and kind of prevent that, and are afraid that if people are operating remotely, there'll be some sort of skullduggery going on. And in fact, one of the requirements is the remote council member has to identify anyone over the age of 18 who's in the room with them, and what that person is doing. Like it could be a caregiver or a family member or whatever. So, in any event, that's the current status of virtual meetings. Yes, Ann.
Can you explain what it means to be authorized by council?
What it means is that the council really has to agree to put the system together and to allow this to happen. Because, for example, if part of the allowing the member to work remotely or to call in remotely is that the public has to be allowed to call in remotely too. That requires staffing, it requires somebody to manage a phone system or a second, possibly an internet connection. So I think cities that are doing it to the extent they can do remote, typically have 2 clerks. And that's a staffing issue, and you have to make sure that your internet is good because if it goes down, you have to stop. So I think that's the sense. Also, the council simply has to agree that this makes sense. Now, the council has to agree to the old-fashioned Brown Act remote thing too, in the sense that it goes on the agenda and goes to the notice, so there has to be essentially a prior agreement. That has never been an issue, or I think we've always done it when someone has requested it.
I have a couple questions too. Official business, is that official city business, or could it be official business of our individual professions or work?
Well, here's what it says. It says, travel while on official business of the legislative body or another state or local agency. So not your work, not your work.
Got it. And then my other question, does anything, or absent council member, does anything in AB 2449 prevent us from allowing the public to comment virtually?
No. In theory, we could do that. In theory, we could do that. But again, I think that's really a staffing issue and a technology issue. Okay.
Thank you.
Mm-hmm. Okay, speaking of technology, now that I've depressed you with this one, let me go on to talk about some of the social media issues that come up in dealing with social media, dealing with technology, dealing with council business. This is, you've probably seen this before, do not reply all. And this is because of a desire not to have an inadvertent Brown Act meeting. Pretty much the only exception to that is if the city clerk would send an email to everybody saying, what's your availability for a special meeting next week on a certain date. It's okay to reply all, but if you do, as we say there, don't editorialize, meaning don't say, I'm available on Wednesday and it's a great project, or anything to that effect, but just deal with availability only. The other issue, of course, is personal emails are disclosable. We've talked about this before. The leading case is from San Jose, where Public Records Act request was made for emails and text messages. And the case came out and went to the California Supreme Court in 2017. It's a reported decision. And the Supreme Court, the city said, well, when council members are using emails on their private devices, not using the city account, they just have a Gmail account or whatever it is, we don't have custody or control of these documents. They're not city records. We don't even know what they are. We don't know if they exist, and we don't control them. And the court said, well, that doesn't really matter. These are, in effect, city records, and there has to be some way to get them, so they are within the ambit of the Public Records Act. The court essentially blessed a process whereby they said, you can simply, the city clerk to whom a request comes in, can request that individual council members do a search themselves, and then sign an affidavit saying, I have searched, and either I have nothing, or here's what I have. It doesn't require the production of private emails or text messages, but sometimes it's hard to know what's private and what isn't. And there can be mixed, the court gives a number of examples about people complaining about coworkers at their city not being a public message even though they're complaining about their coworker. But in any event, the assumption now is that personal private accounts are subject to production of the Public Records Act, and therefore the recommendation always is to keep your official business on your official city accounts. The clerk can search for them in the email server then, and you don't worry about your own privacy issues that way. That's the safest thing to do. And so that has been our recommendation, and continues to be our recommendation, of course. Let's talk a little bit about social media. There are different issues that arise in social media, some of which we have grappled with a little bit here. The Brown Act finally was amended last year to deal with social media. We sent a memo around explaining these changes. There are several changes. Mainly, the Brown Act now says it's okay for a council member to have a social media account, which is defined basically as an account that's open to the public without charge. And the council member can use it to communicate with his constituents, can use it to solicit feedback from them, and can use it to send out information to them as well. It's somewhat like sending a news, it's kind of the analog of sending newsletters out, except you can also get input back from them. What you cannot do is deal with each other's social media account because there's too much danger of it becoming a meeting. So for example, if one of you has a Facebook account, another council member cannot comment on it. They cannot, you can't retweet a tweet from a council member. You can't put emojis on the account. You can't forward something to somebody else because that implies some sort of approval. So these are matters of interaction that are different than the way people normally interact, and that's why we've emphasized that you have to be careful. The Brown Act requirements that allow you to do this are very specific. So, in other words, liking, you can't like someone else's post. You can't take that post and transmit it to someone else. You can't respond to it or send a little happy face emoji or anything like that. So that's an extremely important thing as it relates to not having a meeting. Yes?
Okay, just want to make sure I understand this one, because this now has nothing to do with the number of council members, just any council member?
Right. That is correct. And the reason for that is that if one council member starts to do that, then another one may see it, and you can't control it.
Right, no, I understand that, but okay. Because, I mean, like, Councilmember Tovar just posted about the art show, and I commented, sorry I couldn't be there. Shouldn't have done that.
Our recommendation is not to do that, yes.
Okay, even though I did it as a personal, it was not, yeah.
But who knows what's personal?
I'm just trying to get clarification, because I always thought that, because I know like on Nextdoor, that's what I'm always telling people, is you can't, it's not a fair discussion, because one council, someone could say something and not everybody gets the same opportunity, because it's all been violated now.
I think that is true.
Yeah, no, that I get. I just didn't realize that just a single person on a post about an art show would be something. Okay, so we should just stay off of each other's pages, period. Don't like.
That is the safest, most conservative advice, that you should do that, yes.
City business or not, right?
Yeah, because this
Even
wasn't
personal stuff. Right?
Well, we'll get to that point in a minute about what's city business and what isn't, because that's kind of the next.
Yeah, no, but
next
I think
issue.
that distinction though is whether it's your personal page or your city council page. Some people use their city council page and post personal stuff, or vice versa. Use their personal page but post actual city business on their personal page.
That's
I've
exactly
seen that
right.
too.
That's exactly right, and there are a couple of court cases I'm going to talk about in just a minute that deal with that, which I mentioned to you before, which deal with that exact issue. And it's a very confusing, difficult issue. And the suggestions we're giving to you for the best conservative advice kind of goes against the normal social mores of how we interact on social media. So it's hard to digest, hard to take sometimes, but it is what we should do. Let's talk about what what is personal versus what is public. As you know, there's an issue about public forums, or public forum. And we've dealt with this in the past, for example, like the flag policy that the city adopted last year or 2 years ago. The issue there is if you let anybody put up any flag, then you have to be content neutral. You can only, if you let freedom of discussion reign, you cannot regulate as to content. And the courts will look at this as a public forum, like the town square where people are getting up and saying political views, and saying the only way you can regulate and prevent somebody from saying something you don't like is if it's the narrowest possible regulation designed to uphold a compelling government interest. In other words, what lawyers call strict scrutiny. And courts never find that. There's a kind of a presumption of invalidity. So for that reason, when we set up the flag policy, we wrote it that flying a flag is city speech. It's not public speech. People can apply, the city decides which kind of flag it wants to fly, and that becomes the city's viewpoint. And there you can discriminate. In other words, as a city, we did the same thing. We talked about putting banners across Monterey at one point. And there was a proposal to allow any organization to put up any banner, and then said, well, wait a minute, what if an organization that you really disapprove of wants to put up a banner? You have to let them do that if it's a public forum and you're not regulating it for your own speech. So the same issue arises in the social media accounts, and it arises further with respect to blocking other people's comments on your account. So, and that issue becomes these become U.S. Constitution First Amendment issues. We've talked about this several times. The Brown Act requires that you not block, that the public have access to your account. We believe that this can be subject to certain reasonable rules. And in fact, if you look at the City of Gilroy social media policy, there's an appendix attached to that that's actually a set of rules that I would recommend that everybody put on their social media accounts. Because the law is very vague about it, but presumably you can prevent threats, you can prevent certain kinds of profanity, probably some defamation. You can't prevent somebody from posting just because you don't like them, or just because they don't like you, which is more likely to be the case. Did you have a question?
Yeah, but speaking about that, again, you brought up what I was going to bring up. It's a violation of the First Amendment, right? So if I, on my personal or my city council Facebook, if I'm not allowing anyone to comment, no matter what that comment is, I mean, like I said, if it's negative, it's threatening, I can delete them. But if it's the public wanting me to comment on what I've stated, where's, I mean...
Well, you don't have to allow anyone to, you don't have to allow comments at all. You can say no comments. But if you allow comments, you can't censor them by content. That's the problem. That's, if it's an official account. That's exactly the issue that arises in these cases.
Got it. So if I make a post, I can set my settings where I'm not going to allow anyone to comment on that. That's...
Our recommendation is if you have an account where you don't let people comment, that's better. If you do it post by post, somebody could say you're actually regulating content. Because certain content you're allowing people to say on this post, but on this other post on a different topic, you're not allowing comment. And that's not a content neutral regulation. That argument could be made against you.
Let's say that argument, I'm violating that. What happens to me?
In theory, you could be sued for violation of the First Amendment. The city would perhaps not defend you because it might be something you do in your individual capacity. If you lose the case, you could be subject to mainly attorney's fees. But you could also spend a lot of money defending yourself. And so in fact, let me tell you about two cases where that's exactly happened. Okay? The first case is called Linkey versus Freed. These are both cases that have been taken by the U.S. Supreme Court. So Linkey versus Freed involved and the issue in each case is this account by a public official, a public account or a private account? So in the Linkey case, the court starts out, I think, interesting to see what you think from the way the opinion's written. The court starts out saying, James Freed prized his roles as a father, husband, and city manager in Port Huron, Michigan. Like many Americans, James Freed joined Facebook to connect with friends and family. He created a Facebook profile. In 2014, Freed was appointed city manager for Port Huron, so he updated his Facebook page to reflect his new title. Okay, this case is from the 6th District Federal Court in that area. It concluded that his account was a personal account, not a city account. And they used a test. I'm not going to go into it in detail because it's pretty complicated. But the court basically said he wasn't required to do this account, he didn't use city resources, but it was a very mixed account, and clearly they could have gone the other way. Contrast that with a case called Garnier involving two school trustees. And here's how the court in that case talks about their account. Consistent with the trustees' official identifications on their social media pages, the content of the trustees' pages was overwhelmingly geared toward providing information to the public about the board's official activities and soliciting info from the public on policy issues. I think you can tell that case came out the other way. In that case, the court said, this is a city account, not a private account. And the issue in each case was that the official had blocked public criticism. So those cases are both in front of the U.S. Supreme Court now because the 6th District case, the first one I mentioned to you, said, we disagree with the standards that are used in 4 other federal circuits. And the 9th Circuit, which is ours, which decided the second case, the Garnier case, said, we have read the Linke case and we disagree with it. So it's now in front of the U.S. Supreme Court. It'll be interesting to see what happens. But what it underlines, though, is the difficulty of when you have an account like many people do, where you have personal stuff and business stuff and all kinds of stuff, it can get characterized in a way that might be harmful.
Andy, just to gauge yourself, it's been 35 minutes, just so
Good.
you gauge.
No, that's fine. And in fact, I probably have done for 10 or less. So I think we're in good shape. I know you have this fear that I'm going to go on all night. But so that finishes actually the discussion of the Brown Act. Although anybody who wants to know more about those two cases, I have more information on it. Let me talk briefly about OGO. OGO is Gilroy's own sunshine law. It was enacted in 2008. 2 council members ran for council on the basis that they would enact such a law and that it would sort of shape up the staff that they went against, so to speak. Anyway, so it's been in existence for almost 15 years. It does several things. One is it has its own sections that are sort of like the Brown Act. It also deals with public records. It has some procedural issues. And then it establishes something called the Open Government Commission. The Brown Act requirements in the OGO are very similar to the actual Brown Act itself. They have really hardly affected city practice at all because they're quite similar. They're kind of duplicative of many different things. For example, on closed sessions, they allow the same kinds of closed sessions that Brown Act is. Real estate, litigation, union, that kind of thing, employee performance. They changed the procedural rules slightly, and this is something that council members invariably get confused about. I was confused for quite a while until I finally beat it into my head. And the rule is that if the Gilroy Council is going into a closed session for litigation, then the council solicits advice from the city attorney who advises that, in his opinion, it would damage the city's position to discuss this matter in open session, and the council has to take a vote before going into closed session. That's only for litigation. For any other closed session, we don't take a vote first. For any other closed session, we go into closed session and then take a vote to stay in as the first action. Okay? So in either case, a vote is required, but it's only required for litigation in advance, and for other closed sessions, it's required once we're in closed session. The council votes to stay in closed session or not to. I wanted to mention at the bottom here, I mentioned limited attendance confidentiality, just to underline that discussions that go on in closed session are confidential. They may not be revealed. There's a recent Attorney General opinion on the subject of attendance, because we often get asked by not often, but from time to time, the city's contemplating doing some real estate transaction and somebody else wants to come in, the other side, a broker for the other side, or the other party, or even a litigation. It could be the other lawyer wants to explain a settlement offer. That's not permitted. We cannot do that. That would destroy the confidence of the closed session. The Attorney General opinion dealt with politicians in larger arenas who have staff. And they would have their staff sit in closed sessions. The Attorney General said no. Staff cannot sit in closed sessions unless they're essential to it. For example, it could be a staff member who knows more than anybody and has been active, and that would be appropriate. However, they can't sit in to take notes and just help their council member or their legislator. So it's a very strict opinion, again, emphasizing the confidentiality and the closedness of executive sessions. The Open Government Ordinance also establishes the OGO Commission, which was mentioned briefly. It has 5 members, all of whom are members of the public. It was initially established, actually, several of the members were council members, but by its own terms, that changed to make all the members public members. The city attorney is the legal advisor, according to the OGO. The OGO is supposed to hear appeals of Public Records Act requests. That's very rare, however. It also can propose amendments to the OGO itself, and it can read reports on PRAs, on the status of Public Records Act requests. Yes?
And back on the closed sessions, I want to be clear that anything, any subject matter discussed in closed session is confidential, correct?
That's correct.
It's not just a real estate thing. It can be when we're doing labor negotiations too. That is all supposed to
That is correct.
stay here. Thank you.
That is correct, yeah. Yes, because if it's confidential enough to be a closed session, it has to stay confidential.
Great.
Okay?
Right?
Yeah.
Andy?
Yeah.
But now, what about if we're in closed session and a council member tells a bargaining group or some group something that didn't happen, they're lying about it. They can't get in trouble then, can they?
Well, they don't get in trouble. I guess the answer to your question would be they won't get in trouble for violating the confidence of the closed session, but it might be an unfair labor practice or many other things. So it's not a recommended strategy. Okay. All right. Finally, the Public Records Act. This, as you know, people have a right to the public records of the public's business. Generally, courts interpret the PRA in favor of disclosure, not always. But what's striking is they have no sympathy, as I say here, for the city's workload or expense. There's no exception to disclosure of records because it's embarrassing or it would make the city look bad or an individual council member look bad. So we assume almost everything is ultimately could be made public. And that's a good way to proceed in terms of dealing with documents that you have yourself. From the council's or city standpoint, what strikes me about Public Records Act requests is there's a lot of staff time and cost that goes into complying with them. It's really quite onerous, and generally speaking, they are not recoverable. You can get copying expenses, for example, but not the cost of the person doing the copying. There's a case that involved another city where 40,000 documents were to be produced, and that had to be literally photocopied. And the city said, well, that's excessive, it's burdensome. The court said, no, it's just 40,000 documents, what are you worried about? So, but that's a sort of a typical attitude, for better or for worse. So we have to live with it, but it does sap city time and resources, and in the police department particularly, which receives dozens and dozens of requests every month. Okay, this is my last slide, actually, and just talking about there are exceptions for various things, personnel records, drafts, attorney-client privilege. Police records used to be much more exempt. Now there have been several laws that you probably know about where police records of certain kinds of encounters of using excessive force, sexual abuse, things like that have to be made available. So with that, I think I'll conclude unless anybody has any particular questions. Last slide here for questions.
I have one. Does anything that you discussed here tonight regulate or govern the use of cell phones from the dais to communicate?
Probably not, although that's regulated in our council norms, where we say that it should not be used if a council member takes an emergency family call, they should leave the dais, because it gives the impression of council members receiving other information. And in fact,
So it's
going
not-
back to something I didn't mention in the slide, let me
Sure.
continue for a second. One of the problems of having discussions with applicants, with other people in advance of the meeting, and we talk about, are ex parte communications. For example, if a matter comes to you that you're giving a use permit or something like that, which is a quasi-judicial act, you're supposed to base your decision on evidence received, and everybody can see, this is the evidence received, this is what's said at the hearing, this is what came in advance. To the extent, and that's why we have ex parte disclosures. That's why we have, at the start of such a hearing, council members are asked, have you had ex parte contact, if so, did you learn anything that's not generally available? So the same issue can be raised about cell phone use at the dais. In other words, it can appear to the public that a council member is getting information that is different and is not publicly available, and that could be a violation of due process for an applicant or an opponent of a project. So for these reasons, it's not a good policy to use cell phones at the dais. It's not specifically prohibited by the Brown Act, but it's a bad idea and it's prohibited by our norms.
From here, I'm talking from the dais, because to me it's a transparency issue.
Right.
Nobody
It
else
is.
is privy to a conversation that you're having while you're deliberating.
That's correct.
And that shouldn't be allowed. Okay?
Yeah, I think that's the answer.
The answer is, it is allowed, it's just poor form.
The answer is it's not allowed, it's not specifically not allowed by the Brown Act, it's not allowed by, or it's discouraged by our norms itself. And it could give the city liability in an instance where it's alleged to be a violation of due process because it's secret information that nobody else knows.
Right, that's my point.
And I think you made an important point, Andy, is that if you're having a family emergency, step down from the dais and take your call or do your messaging with your family member and then return.
Right.
to
And that's what our
avoid
norms
that
say,
perception.
our norms
Yeah,
do say
to avoid
that.
that perception.
Okay, are there any other questions, or are we?
Any other questions?
Okay,
Okay, thank you.
good, my pleasure.